I wanted to get your take because I'm not an expert on these issues, so I wanted
Sure.
to get an expert take on that particular ruling with regards to surveillance and privacy.
Sure. So the Carpenter v. U.S. decision is a positive decision, but the thing to remember about it is an extremely narrow decision. So while it's a good ruling in this specific case, it doesn't necessarily have as widespread impact as we'd like. So what happened was Mr. Carpenter, he'd been accused of robbing a Radio Shack and a T-Mobile store, and the FBI, using a Stored Communications Act request, which is different than a warrant, got his cell phone records for 107 days, and those records showed where he was over those 107 days. And the government said it didn't need a warrant because it wasn't a search. Carpenter's attorney said it was a search. And what's really interesting about this case is that starting in the 1960s, for the first time ever, the Supreme Court recognized that the Fourth Amendment didn't just protect your property, it protected your expectation of privacy. So you don't necessarily, quote unquote, own your cell phone location, but you do have an expectation of privacy in it. And it started with a case called Katz. It was about a guy in a public phone booth, and the police were listening in on him, and they're like, no, there's no property interest in this public phone booth. It's a public phone booth. And the court, for the first time, said, well, no, there's a privacy interest. You know, when somebody takes steps to make their acts private and society objectively recognizes it as reasonable, what the Supreme Court thinks society objectively recognizes as reasonable is a whole different story. But then that becomes a search if they transgress that. But about a decade after that, the court announced something called the third party doctrine, which was that if you had turned over your records to a third party, you had no privacy interest in them. It wasn't a search. So, like my bank records, for example, if you're the government, you don't need a warrant to get my bank records. You just need a subpoena because they're third party doctrines. Or there's another case with what's called a pen register. And it's sort of a weird bit of technology to think about now with all of our fancy gizmos. But it used to be you'd have a telephone in your house, and imagine that. I can't remember the last time I had a home phone. Probably not for like over half a decade. But back in the day, we had phones in our house. And police went to the phone company and put this device on the phone called a pen register that recorded every single number it dialed. It didn't get the content of the calls, but it did know what numbers were dialed. And the court ruled that that was part of the third party doctrine. That was not a search to do that. So what the court did in this case was that they said they declined to extend the third party doctrine to cell phone records because it has cell phone location information on it, and that they're not overruling the third party doctrine. It was really interesting to read the dissents because the dissents are like, oh, this is totally in line with the third party doctrine. How can you make this decision and keep the third party doctrine? And in a weird sort of way, I actually agree with the dissent, but that's because they should, get rid of the third party doctrine, not because they should, let us look at everyone's information. So, but the court found that because it has such specific location information, it's more like putting GPS on your car. It's near perfect surveillance, total in its nature, as the court described it. And because of those exceptional circumstances, they refused to apply the third party doctrine to cell phone location records.
So then, how do you feel that it's not enough? Is it because it still sort of upholds the third party doctrine, or what else would you like to see in terms of a decision like this?
I mean, it upholds the third party doctrine, and there's still increasing questions about the feasibility of the third party doctrine in 2018. Like, all of my emails, they're stored by Gmail, they're not stored by me. So, with the way new technology works, all of us to participate in society, we give up massive amounts of information to third parties. We're not doing so because we think it's okay for the government to look into them. So, well, I think the third party doctrine was always very wrongly decided in that if the government wants my bank records, which has, of course, extremely personal information in them, they should have gotten a warrant. It really doesn't make sense in the era of hello, we have my assistant, Marcus. Um, He also thinks the third party doctrine should be eliminated. Funny that my cat shares all of my thoughts on Fourth Amendment jurisprudence.
Cats against surveillance.
Cats against surveillance, Marcus. That's a group for you. Um, but I mean, just the way technology is in the year of 2018. I mean, there's just such a massive amount of stuff with cell phones that all have, GPSs in them. Your phone knows where you are at all times. All of your emails, your electronic communications. You just turn a large amount of stuff over to third parties. And I think the case is indicative of perhaps how the court is going to apply the third party doctrine in this sort of new era where it's a different calculation. I mean, at the end of the day, your cell phone has your location on you at all times. We all agree if the government is tracking you with that type of pervasive surveillance, that's a search, whether or not it's in the third party's hands or not. So I think it's a good sign. I mean, I think, to be fully intellectually honest and consistent, they should just be like, third party doctrine is bad. We should never have decided that. But it does show an unwillingness to sort of do this sort of rote application of principles decided in the 1970s to technologies that have a sort of pervasive and totalitarian surveillance effect that no one in 1977 was thinking about.
Right. So it's basically just a matter of like our laws are so archaic based on the reality of our place and time today. And do you think that this decision could help support or push legislation to basically bring those laws up to date and recognize our current place and time?
I think that's an interesting question since this decision was decided correctly, I would say, with cell phone location. I don't necessarily see it spurring legislation. I mean, if they'd ruled that cell phone records weren't protected by the Fourth Amendment, I could, well, not this Congress, but a better Congress perhaps would respond by passing laws putting limitations on when they could and could not get your cell phone records. I mean, the request they made for the information was a Stored Communications Act request, so it was under the law, and a lot of these laws exist because the Supreme Court just decided, third party doctrine, none of these things are searches. And Congress was like, well, maybe they're not searches, but there should be a privacy interest in them. So they put statutory requirements that in order to get this type of information, you need to have some showing of interest, not probable cause, not a warrant, just a subpoena, but still more than the court would have given us. So I don't necessarily think this case in particular is going to spawn new legislation. What I do hope is that when lower courts hear these new issues of first impression, as they call them, you hear an issue for the first time about different types of technologies, they don't fall back on the third party doctrine automatically. And that's been a lot of what we've been seeing is lower courts making these really dumb decisions about what is and isn't a search. And they go, oh, well, the case law, and they are bound by the case law, but it's like, well, I don't really think anybody anticipated this situation with the third party doctrine in 1970 that, your phone would know where you were at all times. I still grapple to comprehend that. You go in and you see your top location. It's like, oh, your top location is home. And it's like, I'm sorry, how does my phone know what address I live at?
Yeah, terrifying.
Like, it is a little bit. It's like, I've never put this address in this phone. I obviously spend a lot of time at home. That's my phone tells me that's my top location. So it's also judging my social life as well. Uh, but the fact that it's like picked up, like, this address is your home, I guess based on how much time I spend here, it's very revealing information.
So finally, wrapping up, what would you recommend that people do? Because we're obviously not at the point where our laws have caught up with us. Certainly not going to with this Congress, potentially even next Congress, because the Democrats are just a spineless version of the Republicans. What would you recommend that people do to protect themselves from handing over that information to third parties?
So I'm not an expert on technology or digital security. It's not my field of expertise. So I like to leave questions like that to somebody who actually knows what they're doing. I mean, there are a number of precautions you can take to protect your data. I think groups like EFF, Electronic Frontier Foundation, outline them online. I would recommend looking into those and taking those steps. I also would communicate to your elected officials and representatives that you care about your privacy and you want them to uphold it and you want them to pass laws that protect it. And you don't want them to approve judges who, think that your location is a third party information.
Other organizations that you would recommend that people, besides EFF,
Well, I would recommend everyone look at the organization I work for, Defending Rights and Dissent, which you can find our website at www.rightsanddissent.org. And we are a civil liberties organization that works to um, realize the promise of the Bill of Rights, because we recognize that no government has ever actually applied the Bill of Rights, and that certain groups of people by their race or by their gender have always been excluded for it. So we say we work to realize the promise for everyone, and our particular focus is on the right to political expression. So we care very much about how surveillance is not evenly applied. Certain groups, people of color, are surveilled more heavily, and we care about how surveillance is, used to chill political expression.